When I told my client that the defense now wanted to negotiate, he was so happy, he was so excited, thinking that his case was going to settle shortly, until I came back to him with the defense's offer. You want to know why there was such a roller coaster of emotions from the time that I told my client that the defense wanted to negotiate until the time that we actually resolved the case turned out to be an enormous roller coaster of emotions for my client? Come join me for a walk through the neighborhood in this freezing cold day today here in Great Neck as I share with you the answers to those questions. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. This was a medical malpractice case. My client sued a number of doctors and the hospital where he was treated. Now, during the course of the entire lawsuit, the defense had told us that they would never negotiate. The defense had told us that they would never, ever enter into settlement discussions with us. Well, here we are now only months away from trial, and now I get a call from the defense attorney telling me that they've evaluated the case, and now they are interested in trying to negotiate. Would I be willing to negotiate? My response was, sure, I'm willing to listen. Doesn't mean that the case is going to be settled. However, I'm willing to listen and I'm open to listening to what you have to say. So I call up my client to tell him that now, after all these years of the defense refusing to acknowledge they did anything wrong, now they've had the case reviewed internally and have come to the conclusion that it would be better for them to go ahead and start negotiating and to try and settle this case before it ever got to trial. My client was so happy, thinking that he would never have to go to trial. After all these years, he had in his mind that now he was going to trial, that now he'd have to sit in court for weeks, listening to the testimony, listening to these doctors and nurses tell their story, trying to convince a jury that they were right and he was wrong. Now, he really didn't want to go to trial, and I knew that. However, when I told him that the defense was interested in negotiating, he was so happy, so thankful, and so appreciative. Now I go ahead and start negotiating with the defense. I'm very disappointed, extremely disappointed. Their offer is disgusting. Their offer is horribly insulting. And I tell them that. I say, you know what, unless you're serious, don't bother coming back to me with any further offers. And I tell the defense attorneys, I said, listen, unless you are serious about trying to negotiate this case, don't bother coming back to me unless you are really serious about trying to settle this case. So now I go back to my client and I tell him what their offer is. And you know what happens? He is so disgusted. He is so upset. He is so angry. So here he goes from being ecstatic and thrilled that they now think they're going to settle this case to angry. A lot of anger, a lot of venom comes back out. And now he says, how dare they? They knew that they did something wrong. They finally accept responsibility in some way by acknowledging that they want to go ahead and settle this case. And now they come back with this disgusting offer? Absolutely not. Let's go to trial. So now I go back to them and I tell them my client absolutely rejects their offer and don't bother coming back to us unless they have a more serious offer. So now, a few days later, the defense comes back to us and says, okay, we have reevaluated, we've discussed this with our principals, we are now ready to increase our offer to X number of dollars over and above what we originally offered. I said, I appreciate that, however, that is totally inadequate, and it certainly won't even come close. We're not even in the same ballpark, we're not even in the same stratosphere that we can actually begin having serious discussions. So I call my client back up. And now my obligation as an attorney is to relay this information to my client. I need to keep my client in the loop about these settlement discussions because I have an ethical responsibility to let him know about any offer that is made. Once he tells me whether or not he's going to accept the offer, now I have to relay that information back to the defense. And in this instance, I again told them that this was a disgusting offer. My client basically said, go take it and shove it up you know where. But I was a little more politically correct, and I said, thank you for that offer, but that clearly is not going to do anything, not even coming close. So if you're not willing to really seriously increase your offer, don't bother coming back. So I go back to my client, I tell him that I relayed his information to them, and it's unknown whether they will come back to us with an increased offer. Well, a few days later, I do get a call. Now they have increased their offer again. So what's really going on here? I'll tell you what's going on. The defense recognizes that they have a problem. They have a liability problem. They understand that a jury may come back, most likely will come back, and find that their doctor or doctors and hospital staff were careless and violated the basic standards of medical care. However, what they are trying to do is do everything possible to minimize the amount of money that they have to pay out as damages for all of the harms and losses and injuries that my client suffered. And the way they do that is by making lowball offers. And their goal, especially if we don't have any trust from having negotiated or worked on cases before, is to try and settle this case for as little as possible and save the insurance company significant money. So, why? So that they can look like the hero. If they can save the insurance company significant amounts of money, it looks great for this law firm, it looks great for the attorney, and there's a great likelihood that the insurance company, for the doctors in the hospital, will continue to send this law firm more cases to continue to work on similar cases. That's the goal, that's the thinking. In this scenario, they are trying to lowball us. Each and every time they call me, they give me a little bit more, but it's nowhere near what we believe the value of your case is. So what happens next? What happens next is now they are incrementally increasing the amount that they are trying to settle this case for, which tells me a number of things. It tells me, number one, that they have more money up to a certain point, and I don't know where that end point is. Number two, they don't want to go to trial yet. There will be a breaking point. And the breaking point will be when they reach that maximum point where they say, sorry, this is the maximum we are authorized to give, and we have no intention of going beyond that. In that instance, then I can go back to my client and say, listen, here it is. It's either yes or no. You either accept it or you don't and you go to trial. This is where the negotiation has taken us to. Now, we have not reached that point. So with every incremental offer, I now go back to my client, I tell him, okay, they've now increased their offer by X number of dollars. And again, he is angry, he is upset. He recognizes that yes, they're trying to do the right thing and trying to settle this case, but the value is nowhere near what we believe the case to be worth. So he's going on this emotional roller coaster ride. He's happy, he's thrilled, then he's angry. Then he gets a little bit more excited because they've come up with more money, but yet he's still angry and he's still upset and they're not doing the right thing. So for my client, this is torture, absolute torture. And this happens more often than you think. So to go back to the story, what happened here is that I had never worked with these attorneys before. There was a lack of trust between the attorneys, between myself and the defense attorney who was negotiating. And when there is a lack of trust, it is often difficult to break through to say, finally, listen, what's your bottom line number? Or what is your top line number? What's the maximum that you're willing to pay to settle this case right now? And if we don't settle this case right now, do you have any further flexible authority? Do you have any further flexibility to try and settle this at a later point, shortly before trial, or even during jury selection? Sometimes I can get feedback from the defense attorney about whether or not that may be a possibility. Maybe they have to take other steps to talk to other people in their hierarchy to see whether or not it would be worthwhile to try and wait a few days or a few weeks as we get closer and closer to trial to see whether that would trigger a serious discussion that would increase an offer that would be acceptable to my client. That could be a possibility. But because we had that lack of trust, it wasn't there. So here my client is going on this huge emotional roller coaster. Now, is there anything else I could have done differently that would have prevented that? The reality is no. There are some instances where we try and negotiate a case and we say, okay, here's my number. My number is $1 million. Come back to me with either a yes or no. Don't come back to me with $990,000 and tell me that's all you have. It's either $1 million or nothing. You pick. If you come back to me with $1 million, fine. The case is done and over, it's settled, and we move on. If it's not, we'll see you at trial. There are some cases where that type of take it or leave it attitude is necessary, and we have no choice but to follow through with that. Other times, now we are willing to negotiate. So in this scenario here, my client is going up and down, up and down. Finally, he reaches a breaking point and says, I will not negotiate further with them. Let's go to trial, and that's the end of it. And that's exactly what we did. So why do I share this quick information with you? I share it with you just to open your eyes, to help you understand how these types of cases work in the state of New York. I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.